Welcome to the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the city bar.
Hello, everyone, and welcome to another podcast hosted by the City Bar Presidential Task Force on Artificial Intelligence and Digital Technologies, which we'll refer to today as the Task Force. My name is Elizabeth Daitz, and I will moderate this podcast. By way of background, I currently serve as the Assistant Commissioner of Police at the Suffolk County Police Department, and I co-chair the Task Force Subcommittee on Artificial Intelligence and Civil Liberties. Each of the panelists today are also members of the task force and several different subcommittees. I'm going to take a moment to introduce our distinguished panel and then get right into the fact pattern that will form the basis of what I hope to be a lively and even fun discussion. The Honorable Paul Grimm, joining us from the Subcommittee on AI and the Judiciary, is a former United States District Judge for the United States District Court for the District of Maryland, a retired United States Army Lieutenant Colonel with 28 years of distinguished service, and a noted expert on the federal rules of evidence and federal rules of civil procedure as applied to the discovery of electronically stored information. Good morning, Judge Grimm. Next, we have Christian Quinn, who retired in 2021 as the Deputy Chief of Cyber and Forensics for the Fairfax County, Virginia Police Department. Christian currently serves as the Managing Principal of Fulcrum Innovation, a consulting practice focused on the intersection of public sector technology. Good morning, Christian.
Hey, thanks for having me, Liz.
Andrew Warshawer served as the Deputy Chief of the Trial Division and Counsel for Emerging Technologies at the Manhattan District Attorney's Office until just last month, when he left for private practice at the Beasley firm in Pennsylvania. Good morning, Andrew, and congratulations on the career move.
Good morning, and thanks, Liz.
Finally, Jerome Greco is the director of the Legal Aid Society's Digital Forensics Unit. He works with attorneys throughout New York City on cases involving surveillance, digital forensics, and electronic evidence. Good morning, Jerome.
Good morning. Thank you for having me.
So I'm going to kick off our discussion today with a fictional fact pattern, as many of us have experienced either in law school or the scenario-based training that's common in law enforcement. In 2025, a tech vendor that we've fictitiously named Neurotrace Systems sells an AI-enabled law enforcement toolkit called Sentinel AI to the police department of the fictional city of Wexford, located in the state of Franklin. The contract includes a black box provision, which states that the internal workings, training data, and decision-making processes of the AI are proprietary and will not be disclosed to any third party, including the client or the courts under any circumstances. The Sentinel AI suite includes tools for automated surveillance footage analysis, natural language processing for drafting police reports, predictive suspect identification based on prior police data and patterns, and social network analysis to link suspects to others in databases. I'm going to start with you, Christian. What is the existing regulatory landscape in this area, and does it differ across jurisdictions?
Yeah, thank you. It absolutely differs across jurisdictions because, as we know, technology just tends to outpace legislation. And what we tend to see is, if you look at 2024, there was a ton of energy across the US with respect to bills coming forward and governance to be put in place. And some of them passed, but for the most part, they're almost just bills to be considered. If you look at 30 states had collectively more than 150 bills related to governing AI come forward last year, and we're seeing similar this year. And I think the challenge is there's a lot of energy around wanting to do something and not clarity on precisely what needs to be done. And that, unfortunately, doesn't make for the best policy environment. We want to believe that everyone has good intentions there, but I think both policy writers, bill writers, and just the general populace is probably a bit misinformed at this point around artificial intelligence. The other thing I would say is generative AI, like your chat GPTs and Geminis and things like that, have kind of like thrust artificial intelligence to the forefront. But algorithmically assisted processes and things of that nature, they've been around for a really long time. And they've also already been introduced in places that perhaps should have concerned us before, but certainly are more at the forefront of consciousness now. So at the risk of not really providing a clear answer, I would say that's probably encapsulates the policy environment right now. And it's sort of all over the place. So to sum up, there is a lot of pending governance. And in some of these policy environments, what we're seeing is well-intended guardrails, and that's good. But we're also seeing parameters around use, such as impact statements or algorithmic vetting and that kind of thing. And the challenge there is when we put that in place and mandate it, now our stakeholders are on the hook to comply with that. And I think that requires a lot of forethought. Like, can some of these things even be done? Can those issues even be unpacked? Are there entities out there that provide that as a service?
So, Christian, if you are a police chief, as you have served us, but you're in our fictional city of Wexford, and you're engaging with a technology vendor in this kind of regulatory morass that you've described, what would you look for in terms of racial or confirmation bias in a product like Sentinel AI? How would you satisfy yourself that that product is not going to have unintended outcomes?
So here's the biggest challenge with probably all technology, but particularly with AI, is this notion of explainability and inscrutability. We can unpack how a neural network works. We can discuss from a technical standpoint the math and statistics and tokenization around large language models. The real challenge is explaining the outputs, because we could prompt a large language model with precisely the same prompt and end up getting a different output each time. And that opens the door to questions around fairness and equity. And it opens the door to questions around accuracy that are really paramount. If you look at large language models, if you look at GPTs, they tend to catch a lot of flack for hallucinations and inaccuracies and things like that. And I've really come to rethink my own stance on this. GPTs, LLMs specifically, were never engineered to be truth machines. They were never engineered to be fact machines. They do what they do really well in that they assemble text and characters based on probability of arrangement in a format that constitutes really semantic, good text that sounds conversant, that sounds like you're interacting with somebody on the other end of it. And because of this notion of anthropomorphism, this feeling that I'm interacting with a being that has awareness of this, and I'm not diminishing the power of LLMs. They're remarkable, but they also are very limited. They don't know anything. They're not forming thoughts. They're just assembling text in a very predictive way and giving you an output that sounds really compelling. It sounds really good. So I think the challenge is really, it's on us as individual users and adopters to really vet these outputs and to really think about how they come out. And I'll touch upon it a little bit, but if you look like one of the positive things in the White House order that just came out is this desire to be able to better explain the inscrutable nature of generative AI in particular. But to your original question of, if I'm a police chief and I'm looking at doing business with a vendor, I do want to look at the conduct of that vendor. I do want to look at to the extent that they can explain. And I think we are in an era where balancing proprietary protections of how tech works, that default to you can't see it, that's not going to persist. We're seeing rulings now where they're saying, hey, show them the source code. We're seeing rulings now where they're saying, hey, we want to be able to, the defense needs to be able to look at, if you reach this conclusion using this tool, what's the underlying mechanism? What's the secret sauce, if you will, as to how that comes about? Furthermore, like a more basic question is, was a tool used at all, whether it's facial recognition, predictive analytics, or things like that? So I think we're entering an era where vendors have got to be on board with that, and they've got to expect that. But I would also look at the point of development, right? If we look at like the true sources of bias in AI systems, you've got that computational statistical bias at the time of engineering, when the thing is first modeled, when it's first built. Are your data sets sufficient to perform the task that you're going to have it perform, regardless of what it is, whether it's predictive analytics, facial recognition, what have you? The systemic bias, how are we going to use it as something can come out of the box, if you will, so to speak, metaphorically, and you start using it and you start putting data into it and you start pulling on different sources and your users are doing different things with it. And the more it has the capacity to the model has the capacity to evolve from those contextual uses and adjust the outputs. For better or worse, the more slanted those outputs are going to be. To what extent are the controls in place to make sure that doesn't start going off the rails and the tools don't start adopting or adapting to your users in such a way that it's no longer impartial, or it's no longer what it was meant to be when it first was adopted. And the last thing is that we can't discount is people are part of every system. Human beings bring what they bring, whether that's implicit bias that we don't need to go into depth on, or confirmation bias, which is huge when you're using a tool and new information is presented in such a way that it affirms what you're already thinking. It's very easy to latch onto that, and it's very easy to discount things that are contrary to perhaps your current investigative theory or what have you. And then just the basics of automation bias, right? When a tool is really powerful and it tends to get it right over and over again, we tend to develop this complacency where maybe in the beginning we're scrutinizing what we're seeing because we're like, oh, it's new, it might not work. That 3 years down the road, it's like we just take everything at face value because it's you look at examples of people following their GPS on their phone into cornfields and things like that. Like, people defy their own common sense because they think this device or this algorithm, or jokingly Siri, must be smarter than me, must know something I don't know. And as humans in the loop, as workforce, we've got to continue to push that it's never good enough that it replaces our own judgment. So those are like probably the key things that I would hone in on. And the last thing I'd say about that is anything I implemented, especially something that incorporated generative AI, I would look at that in the beginning as some kind of iterative pilot where we're gathering data, we're doing a small set, and we're really looking at like, hey, is this doing what it's supposed to be doing? Is it accurate? Is it giving us the results that we want? And the first question is, right, everybody's chasing shiny balls right now because it's exciting and new and that kind of thing. The first question is, do you actually need a technical system to do the thing that you're doing? Or is the way you've always been doing it? And I'm not going to defy innovation, but sometimes you don't need the new whiz bang factor. Sometimes, whether it's analog or the digital system that you're currently using, that might suffice. And that's not a bad thing.
Christian, I love that. And I think that's great practical advice, especially in law enforcement, where we are bombarded by vendors looking to sell expensive things to solve problems that we as organizations may not have defined yet as a problem. So I think that idea of, do you need a technical system to perform the function that's being performed by either your detectives or your crime analysts or some other human asset within the organization is a great point. Is this as, doomsday a scenario as it sounds? Should police departments just back off engaging with artificial intelligence until we are better suited to negotiate contracts that protect the agency from exposure or liability, or that align with civil rights? Or do you think that there's room for police leadership, law enforcement leadership, especially in the United States, to self-educate and understand where these guardrails might be, such that we can live in a world that balances innovation with best practices?
So a couple thoughts on this. I think that we don't want to tell our workforce like, hey, just hold fast, don't touch this, because that defies the power of the tool. At the same time, we don't want to just jump headfirst into the thing with no consideration for some of the limitations of the tools. So I think we want to look at use cases, right? Are we using these as a means to enhance some kind of organizational efficiency, or are we using them to make decisions of consequence, right? So if we're talking like some kind of like facial recognition system, we want to be exceptionally mindful of algorithmic accuracy, demographic performance variation, cyber and data security issues, workforce training, and looking at those guardrails that we put in place and being very rigid with those, and making sure if the system or the people deviate from what we intended to do, that we're quick to take corrective action or take it offline. That being said, if we don't have governance, then our younger members, in particular of our workforce, and more technically savvy people, are going to start freelancing. They're going to start doing things that we don't want them to do, and maybe using like ChatGPT or Gemini or some other tool or Grok, and putting police data and things that we don't want in these open models, trying to realize their own efficiencies. So I think we have to engage at every level of our organizations and acknowledge like, hey, these are powerful tools. I worry less about the folks who say like, oh, I've never really used it, I'm nervous about it, than I do the folks who have been using ChatGPT for over a year or Notebook LM or some other tool and believe themselves to be experts without the awareness of where these things are mathematically flawed. There's a good study out around like document summarization and what it misses, and generating things like Excel workbooks and stuff like that. Like it's wrong 0.7% of the time. Well, if you're like doing party planning or something for your house, like 0.7% is an acceptable risk. If you're doing your crime statistics, if you're doing a workforce analysis, it's not just 0.7%, it's 0.7% in the first tier of the process. And each point in the process down the line, whether it's pivot tables or formulas or what have you, that degrades even further. And I would submit to you that like when you start getting up around a 5% error rate or a 14% error rate, that is unacceptable for use in the workplace. So I think having that knowledge and that understanding of some of those limitations is paramount. But I also think we don't entirely back away and say, oh, we're just not going to use this. You can imagine like in the early 2000s telling people like, hey, we're not going to use email or the internet. Like we'd be completely foolish because now it's like completely ubiquitous. But then again, we probably missed the boat on a lot of things along the way with respect to cybersecurity and data privacy and things like that. Now we know what we know, and we've got to be really smart about adopting these tools that are so powerful, but still limited and still evolving.
Thanks so much, Christian. And I think, like many issues in law enforcement, what you've described is partially a leadership problem. So I surely appreciate your leadership on this issue. And we're going to pop back into Franklin, the state of Franklin, back to Wexford Police Department for a moment. So Wexford Police Department, without the benefit of Christian's stellar guidance, goes ahead and uses Sentinel AI with its black box provision in their contract during the investigation of an armed robbery at a local pharmacy that resulted in a clerk being shot. The Sentinel AI flags surveillance footage from nearby cameras, enhances it, and generates a report identifying one Nathan Reyes as a suspect. The Sentinel AI product drafts portions of the initial police report, including suspect identification and location, and it suggests that Reyes is likely connected to a gang based on prior unrelated contacts and associations mined from departmental databases. Reyes is arrested based largely on the AI-generated outputs. The prosecutor, ADA Han, then uses another AI tool called Transcriptomind to review over 3,000 hours of recorded jail calls and surveillance audio related to Reyes and his known associates. The AI flags segments as potentially incriminating and produces a batch of highlighted transcripts, which the prosecution uses to support its theory of conspiracy. So I'm going to turn to Andrew, who has led a great deal of work in this area as a former prosecutor. And I'm going to ask you, does ADA Hans, in our fictional narrative here, do her discovery obligations extend to algorithmic processes or only to the outputs?
So I'm not aware of any state that has a current statutory mandatory discovery rule that attaches to algorithms. But there wouldn't be much of an interesting podcast if that was the end story, and that is absolutely not the end of the story. This factual scenario brings up a couple things that sit prior to discovery, and I want to move through them quickly. But one that we've encountered in law enforcement for a long time now, right, is we have had this massive amount of data available to us. Large data sets, undifferentiated digital stuff. Hours upon hours of jail calls, social media pages, location data, email accounts, financial records. And I think one of the big secrets in law enforcement is those products of kind of surveillance capitalism, or whatever you want to call it, have largely been usable only in the most high-profile cases and in limited fashion, because no one has the time or the resources to examine 3,000 jail calls in every case. That's about to be over. That era is going to end in the next 6 to 12 months, where all the undifferentiated stuff we've been gathering for a long time, it's all going to become usable. And I think to the earlier point that was made, right, the generative tools get a lot of the press. But the first real killer apps, I think, are going to be turning gigantic data sets into usable insight in a way that we have not really had access to. So turn to this example, right? One of the things we have in Mr. Reyes's supposed case here is the distillation of social media and other contacts into a conclusion that he's in a gang or a suspect identification. So I want to turn to discoverability in a second, but the first problem is, what did that tool access, and was it allowed to access it? Did that access search warrant material? Almost every jurisdiction has protections on what can be done with material seized by court process. Can you take material from case 1 and examine it for leads in cases 2, 3, 4, and 5, remote in time, years to decades later? I mean, I'd love to hear Judge Grimm's opinion on this. I'd imagine the answer most of us suspect is no. I've never seen binding case law on it, and I don't know who would enforce those rights. So these are policy calls that I think are very difficult about when you've collected things. And search warrants are the most egregious example. But there's administrative subpoena, there's grand jury process. There are things that bring evidence into our lives as prosecutors and as a government that are intended to limit that use in ways that just were practically easy when it was in a box, harder when it's on a hard drive, next to impossible when they're accessed by something like a proposed Neuralink or whatever the tool might be. So I think before we even get to discoverability, we've got to start thinking very intentionally about, I've got data, I have cross-cutting obligations with that to prove my case, yes, but Brady obligations in the future, Giglio obligations about witnesses we may call. For what purposes can a tool access it, and when, and by who, I think is worthy of its own several law review articles right now. I think those are questions we've all kind of danced around for a while. When we gather stuff, and I know Andy Warshawer's phone number is X from case 1, and it shows up in a wiretap case 3 years later, can I check my own records and say, I can already resolve who this phone number is? We haven't really confronted that as a profession. And I think the question is going to be called much more directly over the next several months to a year because of these technologies. And it's not generating. This is the review stuff that we have very, very good access to. So there's no state that's approached it statutorily that I'm aware of. That doesn't mean the courts haven't tried to weigh in, and I'll get there in a second. But this is probably the first place I think that criminal justice involved policymakers need to be very intentional. The uses of these things are going to inform the law that attaches. So I don't think blanket you're ever going to have a rule that says processes are discoverable. The context in which we use them is going to matter a great deal. So if you want to use the conclusions of a tool as evidence in court, I would almost guarantee you that the bench is going to rule whether there's a statute or not, that the process that produced that conclusion, this social media profile is in fact Michael. That's going to be discoverable. And we've seen that. We've seen that in cases involving probabilistic genotyping. The really fancy, we've got 5 samples on a gun and we want to resolve it to one person. It's not every case, but a Fry hearing or a Daubert hearing, you're going to end up having to produce that code. We've done it in New York under seal. I know New Jersey did it. Our case was, I believe, it's a really standard. I think it's Williams in New York, and I think it's Pickett in Jersey. But we've had to produce those, right, and litigate them. And once they're litigated, they might not come back. We did it under seal. I think Jersey did it under seal. But if you want to use this stuff in court, you're going to litigate it. I think it's closer when what you want to do is say this formed a link in the chain of investigatory probable cause that then led my investigators to go do the thing independently. And by that, I mean, the AI process reveals that your phone by MAC address or IMEI pinged off a router somewhere. And we then run out and grab that router and find your IMEI. I don't think that you're going to necessarily have to produce the source code that led you to that router in the first place. And I think there are analogs in our law, like informants and anonymous calls, where you're going to need to have someone who's smart enough to talk about the thing. I consulted this tool, it led me here, that led me to gather this piece of evidence. But I think that'll be hotly litigated, right? I think the defense bar is going to have a very different take on that. I'm trying to purge my mind of my former prosecutor bent, but it's only been a couple weeks. And I think we probably survive having an intelligent person speak about what that tool does and what it produced. But again, you've got to know what your use is going to be up front. There was a terrible case of this in the Ninth Circuit with a company I liked doing business with who's gotten, I don't want to name them directly. I don't know who's listening to this necessarily, but there's a vendor that did a lot of digital analysis of your kind of trail you leave unintentionally through cyberspace. And it's a great investigative tool. And it can lead you to things like IMEI addresses and routers. But somebody tried to put them on the stand and have the CEO say, this digital profile is John Smith. And that was just an incorrect use of the tool. It blew up. They were disqualified. There was hugely critical opinion of them. And I don't think it was a problematic use of technology. I think it was a problematic policy call by the lawyers involved to try to offer that testimony to a jury. So I do think you've got to be very careful about the use you want to make of things, and that will inform discoverability. And the last thing I put in there, like, discovery in a criminal case is one theory that gets this stuff in front of a judge. Another, as we've just discussed, is the attempt to use it as admissible scientific evidence. The third would be probable cause, which we kind of discussed. And the fourth, that I think is the scary monster out there for all of us, is Brady and Giulio. There are theories that compel us to turn things over, whether we want to use them as evidence or not. And for a prosecutor to just answer, as you sit here today, what does your office know about the Andrew Warshawer you're going to call as a witness next week? If anybody says they have a 100% confidence level answer, I think that they're wrong. And I think that's very scary for all of us. And I think we're protected if at the policy level, and to your point, Elizabeth, the leadership level, we say our approach to Brady, Giulio, and artificial intelligence is X, and it was followed here. I think it's going to serve everybody very well. I also know very few prosecutors' offices who have a policy like that. I think most of them are aware, was described before, right? Don't use it, we'll get back to you. That is not tenable anymore. It might have been okay even 12 months ago. I don't think you can pull off that policy today. And I think getting specific and getting intentional about how we're going to use these things is a prerequisite for anything else.
Andy, I love the way that you speak to this intersection of the technology, policy, and the law, and really broke down the kind of moments across the prosecutorial process where different evaluations are made based on the same, I'm going to call it an output from the use of technology. So there is this question, and you started by saying, like, let's back up even before discovery. So I want to do that. I want to go back for a second to the question of probable cause. But you walked us through probable cause, discoverability, admissibility, and the Brady and Giulio elements of mandatory disclosure. Going back to that probable cause question, do you ever question whether or not the underlying technology used to support an investigation whose results give rise to probable cause is so faulty or so even unclear to you, or to Christian's point, replete with confirmation bias, that you would question the existence of the PC?
I think you have to, and I think that's very tool specific. So again, I think this gets back to leadership, right? This gets back to somebody, rather than saying, I've put out an email saying, don't use this, and my head goes back in the sand for 12 months. This is how you have to engage with a tool like this. What these tools are great at, in my experience, limited as it is so far, is surfacing things that would have taken hundreds of hours to find and pulling them to the forefront. What it's very bad at is telling you the importance of those things, either relative to one another or to the case. So as an investigative aid, I think they're fantastic. And I think in the few places before I left that we really did engage with this, that's what we did. One was, I want to find this red car in thousands of hours of video. That sounds uncontroversial. I want to get to your point, Elizabeth. I don't want to dodge, but I think examples are very helpful. Even that, find this red Honda. That bakes in some policy biases, right? Like, where are you going to set the fault tolerance? Is it every red car? Is it every Honda? Is it everything that could up to 80% probability be a red Honda? And then what are you doing to the investigation by focusing in that narrowly? Having made the right call at a human level that the red Honda is the thing to look for? Or should you also be looking for every accompanying car that's with it? We do this with clothing as well. You find the yellow sneakers. When a human watches that, they're going to see, oh, those yellow sneakers always appear next to the guy in the fedora. When you tell the computer program that, it's not going to give you that, at least not yet. So you need to make very important calls, I think, about how you use this stuff to screen, because what you're going to get, even at the best usage right now, is an investigator whose attention is now called to a set of things, and by definition, told to ignore another set of things. And I think that's scary. I also think, it's where we are now. We can't look at everything. So take an example of reviewing jail calls. Everyone's got their science. Some people listen to the days around court dates. Some people pick important phone numbers. Some people spot check, but they're ignoring stuff today. The AI is going to tell them to ignore different stuff and possibly better guided stuff. But it's not like we're going to move from a world in which everything was reviewed to a world in which the AI is telling you what to review. We're going to move from a world where the personal bias in what gets ignored is replaced by an AI bias in what gets ignored. And to come back to probable cause, I think that means the best practice, which I don't think we can always follow, is to do the investigation, use the tool, see what it gives you, and hand it to a person who never had an engagement with the tool, and let them go and assess that case on their own. I suspect in very high profile cases, that is what is going to happen. On a quadruple murder, say the person in New York a couple of days ago had survived the office shooting. I think you would get a very sophisticated policy call to have that investigation done, tech enabled, and then blind to the AI tech. I think best practice in discrete elements, we're going to get that. And the policy I left behind, which I hope they will follow at my office, was when you produce a transcript, for example, jail call transcript comes out of the AI, it's for investigative use only. When you want to present that to a jury or a grand jury or a fact finder, it's got to go back through the normal process and given to a human being who's never seen the AI transcript to transcribe. So you know much more quickly which calls to look at, but you're getting the same quality product you were getting before. I think that's reproducible on some classes of evidence, not others. But I think the best advice I could give an office, police department, or prosecutor would be, if this was not probable cause absent AI, it is not probable cause with it. And you should approach this AI like you approach a cooperating witness. It is a nice to have. It can narrate. It can guide you. It is not a thing that should put any weight on the do I have PC scale or not.
That's great pragmatic guidance, Andy. I really appreciate that, especially about duplicating steps with people who are blind to what the AI generated. I'm going to ask you one last question, Andy. Just opine on the national conversation. I'm not trying to put you in a position to speak to the dialogue specifically between your former office and the NYPD, but do you think at the national level that there's enough of a dialogue between law enforcement and prosecutors about policy guardrails on tools to inform the viability of prosecution? Do you think that we as police departments are paying enough attention to the questions around PC discovery, admissibility, Brady, Giglio before we hand you a suspect in a case?
It has to be informed by my kind of localized knowledge here, but I've worked with other police departments, so please don't take this as an NYPD only answer. I think the discussion is a lot better than it was 3 or 4 years ago. I think it's still really insufficient. And I think organizationally, this is boring, but there aren't really kind of product owners for AI as a whole, for technology evidence as a whole. I took that role in my office a bit, but it was even an odd and clunky function for us at first. And I think that is, from an organizational perspective, something people need to build. You need to build a kind of point of light, a beacon, whatever you want to call it, for engagement at the police department level with the court system, the prosecutors, the defense bar, and the other kind of ecosystem players here, so that people know, we're adopting a new thing in the police department. Somebody's got to know what this is before it's litigated 3 years from now when someone figures out that we used it. And I don't think police departments are hiding the ball. I just think that they have a very different mission. They are public safety agencies, so some technologies they employ have nothing to do with contemplated litigation. There are police department personnel level devices that are going to protect officers' lives by monitoring, biofeedback and biometrics in real time that have nothing to do with criminal prosecution, but then may become relevant. And no one's thinking about that up front. A heart rate monitor on an officer on the street can prove a number of things. But when they pull that into the department, it's to protect their officers. It's not for later litigation, and nobody is thinking about that. So I think building that organizational capacity is very important. And then the conversations I think that are difficult are, how does this play out in the courtroom? Even in the criminal investigation world, your imperative as a police department is probable cause. Prosecutors beyond a reasonable doubt. And there's going to be an inherent tension between the desire in police departments to close cases and our desire for more proof in the prosecution world. That's played out for generations. And I think this is a new battlefront there, but I think if we can take that first step of getting people deputized in these organizations to lead here, we're going to be in much better shape a year from now.
That's awesome. Thank you very much for that, Andy. I'm gonna dip us back into our hypothetical here, where defense counsel learns that Wexford PD and prosecutor Hahn have used AI through a whistleblower in the vendor's company. And the defense moves to compel discovery under Rule 16 of the Franklin Rules of Criminal Procedure and to exclude any evidence generated or derived from AI on the grounds that the prosecution had not disclosed how the AI tools operate. The black box nature of the technology violates the defendant's confrontation rights under the Sixth Amendment, and the AI generated conclusions are unreliable under Daubert and Rule 702 standards. So I'm going to turn to Jerome and first ask whether the defense can meaningfully confront evidence that's derived from an algorithm that is opaque to you.
No, I don't think the defense really can. And I think it's part of the problem here is that I think, what Christian had mentioned earlier, which I agree with, that you can know how it was programmed, you can know the data that was inputted, but, one of the major problems here is you don't know how it actually came to its decision. And you can try it twice asking the same question or the same prompt or to solve the same problem and get two different answers. And that's a significant issue for me because who am I questioning? Who am I cross-examining on this? And if I do this the other way, right? We've seen this when it comes to mixture DNA software testing, right? You have a company like StarMix, you have a company like TrueAllele, and you could run it through both and get a different result. And now we're playing battle of the black boxes between who calls defense and who the defense calls and who the prosecution calls. And that seems like a mess to try to then put onto a lay jury to understand what any of this means, no less how they should weigh it and what they should put it in a trial. And so when you get this result that comes from a proprietary opaque algorithm and say, here, you could question about it. That's just not actually realistic for me to be able to do. Who am I questioning, right? Who am I confronting? And, I wanted to go back to something that has been touched on a little bit here too about investigatory leads, right? Because a lot of this doesn't really come up until trial, right? If we get to that point and it's going to actually be used at trial. And as we know, much of it never gets to that, right? Either because trial doesn't happen or because it's not intended to be admitted at trial, right? We see this most commonly now, I think, with facial recognition, right? Or at least that's the hot button thing, I think, for everybody is facial recognition. The problem that comes from that is that it's not truly just an investigatory lead. We see over and over again that people, when they get a result from a computer or from a machine, that they are reluctant to say it's wrong, even if they would have before they got it from the machine said it was a different answer, right? What ends up happening is that you get a possible match from facial recognition, right? You'll get up to 250 possible candidates, and then a detective or an officer pulls one of those candidates out of that list. I said, this is not enough for probable cause. And I agree, right? I think we all agree that's not enough for probable cause. But here's a potential lead. But we've now given it to the case detective, and that case detective is now not going to say, I'm going to just investigate and see who did this. They're going to say, how can I get enough to establish probable cause that it's this person? And so they start looking for evidence for this person, not necessarily for evidence in general. And they not intentionally, but ignore things that may contradict that. And I don't think, again, they're people. Judges are people, lawyers are people, officers are people. That is an inherent bias that we have. It's hard to put that aside. You get tunnel vision. And as an officer, I imagine I'd be like, great, I have a lead on something. I didn't know what to do with this. And so that's what I'm going to chase down at the detriment maybe of other things. And I have seen this play out in a worst case type scenario. We've all seen the false arrests that have occurred due to facial recognition, but there's a lot more out there. It's just that most people don't want their name in the New York Times or the Washington Post when their case gets dismissed. And I know of cases that have happened right here in New York City where I know there are false arrests based on facial recognition. But even if you put that specifically aside, I've seen situations in which they take the facial recognition match, put it into a photo array to show a witness. The witness says, I'm not sure. I don't know. Okay, fair enough. They document then, they turn that over as discovery and Brady. I appreciate that. But then they run it through a pattern recognition program to see if there's another case that's like this one. And they say, oh, this is a 60% match. This burglary is a 60% match with this other burglary. Why don't we show that photo array to this other complainant? And now they show that photo array, and that complainant says, yeah, that's the person who I saw running out of my apartment. And now you're getting charged with both cases based on that pattern recognition, even though the original case, the complainant couldn't recognize the person. So yeah, it's hard for me to then to say, where can I do a Daubert Fry challenge or for evidence for discovery that's never actually coming in at trial? Because they're not going to put that facial recognition, that pattern matching in at trial. They're just going to put the witness up and say, I recognize who that is. But there was a lot that led up to that point that is significantly flawed. And I may never actually get to challenge that.
The New York City Bar Association is a dynamic community of over 23,000 legal practitioners. Members shape the future of the legal profession, serve the public, and gain an edge in their careers. To learn more about becoming a member of the City Bar or to join today, visit nycbar.org/join. Save 20% on semi-annual dues when you join. Call Customer Relations at 212-382-6663 and use code POD24.
Jerome, I'm going to ask you the same parade of horribles question that I asked Christian. In your mind, should law enforcement use artificial intelligence enabled technologies? And I'll, lump facial rec and the review of jail calls and, need to find the red car in the visual space. Like, where's your limit on what is or isn't okay? And the kind of companion question there is, if the chief of Wexford had hired Christian to conduct an algorithmic bias examination of the vendor software and the contract was not a black box contract, would that change your opinion about the validity of the use of technology or its, I'm using the wrong word, but impeachability in the context of a criminal prosecution?
So to go to the first question about can law enforcement ever use AI? Yeah, I'm not somebody who thinks that all technology is bad. I love technology, frankly, or that all AI is bad. And I think Christian pointed this out, and I think he's right. People don't realize just how much AI is just standardly being used. When Microsoft Word tells you spelled something wrong, it is recognizing that against a dictionary definition. I'm not worried about Microsoft Word telling you your grammar is wrong, right? I am worried about draft one writing the report for you and then you signing off on it. That I am worried about. And so I think for the defense side, a big part of this is, where is there somebody who can be held responsible if this is wrong or if this is a mistake? Can people be questioned about it? And is it something that I can review myself and then say, okay, you say this, but here's what it actually looks like. And so perfect example of that is automated transcription, right? And I think it's come up here, and this definitely on both sides of the fence here with the jail calls, right? Having hours upon hours of jail calls, right? And having something auto transcribe that, it's not going to be perfect, but you're going to be able to go back and listen to it. And I'll be able to listen to it. And we may disagree about what was said or the intent of it, but that actually gives me the ability to challenge that. And you can still use that. So those are things that I don't think are wrong to use. And I appreciate that. I think those are innovative technologies that we should be adopting and making better. But when you start doing something where I can't actually challenge it, I can't review it, I can't run it myself, or it tells you this is the person, right? Or this person is guilty, or this person is in a gang. And the gang thing I think is really important too, because again, that may not come in as evidence, right? It may be more prejudicial and probative. It may not be relevant. It may never come in, but we all know that if you're being told that this person is likely a gang member, that offer you're going to make is going to be affected. And I know this just from talking to prosecutors. They say, well, I think your client's a gang member. I'm not going to give him that offer because I think he's a problem. And look, I get that's part of the calculus, but that is now being part of the calculus that I can't challenge. And so a lot of this comes down to, are these things I can challenge, that I can show a jury, and I can actually, if I'm correct, have it either kept out or be able to convince a jury that it's not correct. And if I can't do those things, or I'm not given the opportunity to do those things, then I think it can't be used. And to go back to what if it's not a black box, right? I think was the question. I definitely think that's better, right? But there does become an issue, and I think both sides have dealt with this. And sometimes I think prosecutors will call it the CSI effect type thing, which is you're trying to explain very complicated technological issues to juries who don't understand that, right? There's going to be people on those juries who call up other family members because their TV remote's not working. And now you're trying to explain to them algorithmic bias and black boxes and machine learning and neural networks. And that's really difficult. And so I still think there's issues there, but I'm hopeful that those issues can be overcome if it's something where it's not black box. I can get access to the source code, the training data. I can try it myself. I could run it. I can see the issues. I can hire my own expert to take it apart or not. And as an example of that, we saw that with OCME having what was FST, a forensic statistical tool, right? And defense was prohibited left and right from being able to access the source code. And once a federal judge ordered it, we saw an expert say, actually, it's arbitrarily dropping data. And I haven't really seen FST used since, but there was a bunch of cases where that challenge wasn't really being able to make, right? Now people have moved to like StarMix and TrueAllele. And so I think it being a black box is a significant problem, but it's not the only problem.
Yeah, and those are great points. And I do have this, I'm going to pull the thread a little bit on this litigation strategy question. Is it case by case based, or do you have kind of a general approach to whether you'd call an expert to testify about unreliability or bias, or would you focus on the procedural and constitutional objections to the admissibility of the outputs as opposed to trying to get that expert in before a jury? And I'm the person who calls my sister to figure out how my TV remote works. So I appreciate that analogy very much.
Yeah, no. And look, I think most likely one of the benefits of being in the defense is that I can take more than one shot at the apple. And so initially, my initial first challenge is going to be procedural and constitutional objections, right? If I failed there, then yeah, I may hire an expert to testify depending on the circumstances. And I do have to weigh that. And part of that may be how significant the evidence is in the case, right? Also, how likely I think that the person who the evidence is being admitted through is capable of answering my questions, right? Because that happens sometimes too. I see this with cell phone extractions, right? And an officer says, this is what the report says. And I have to explain, yes, but the SQLite database that was unparsed said this. And they look at me like I got three heads. And so part of it also depends, is the person who's admitting it actually capable of giving those expert answers? Because then I may be able to just point through them, if they're going to be honest, be able to acknowledge, yes, this may be a problem and this may be a problem. And I may not have to call my own expert. But so, yeah, it is a little bit case by case basis. But I think almost always my primary challenge would be the procedural and constitutional objections. Because again, I would try to avoid having to convince a jury of these very scientific issues.
So I have one last question for you that's more systemic and institutional. You serve in this unique capacity in the Legal Aid Society. Yeah. Are there barriers, economic or otherwise, to the defense access to or engagement with emerging technologies? Are there things that you see on the law enforcement or prosecutorial side that you feel would benefit the defense bar to be more widely available or be tailored for the purposes of defending a client in a criminal prosecution? So, and if there are, how are you sort of tackling those challenges?
Yeah, and my unit, one of the main reasons we came about was because of that. And we saw the prosecution using cell phone extractions and law enforcement doing that, which I think is legitimate use of technology, assuming you have a warrant and abide by it, right? And I saw that as a missing opportunity for us, because we have plenty of times where we could also be able to get that evidence and be able to now say, hey, this is reliable because it was done properly. But there are companies who won't sell us some versions of those products that can actually get more data. And we've been fighting with them about that. We thankfully were able to get one of them. Now, I won't mention names, just not to cause problems for myself in the contract, frankly, but one of them allowed us to change their terms of service to include criminal defense. Because right now, most of them have explicitly in their terms of service saying it can't be used for criminal defense. And so, of course, they don't sell it to us. Or they say, we'll sell it to you, but you can't use it for criminal defense, which, of course, is useless to me. And so I do think that that issue has come up about also in social media context, being able to preserve or find social media. There's a lot of those companies won't sell to us. And the real big thing is that I'm incredibly fortunate, and my organization is incredibly fortunate. Most public defense offices do not have anywhere near the tools and staff that we have. And I constantly get calls from people asking, how did you do this? How did you get the money for this? And we try to help as best I can. But in the long run, as with everything in public defense, is do you have the money? And when you have this pot of money and you say, can I lower caseloads for staff? Or do I get a very expensive license to a phone extraction tool? A lot of times they're going to hire more staff to lower caseloads. And that's a really tough decision that shouldn't have to be made, but is.
Thank you for that, and for your candor and expertise. I think there's a lot of alignment on the law enforcement side as well with, whether we're going to hire people and throw bodies at the problem, or if we're going to do the ounce of prevention, pound of cure approach that's incredibly uncommon in government, but we can, solve the problem in unique ways. So again, dipping back into Wexford, right now we have a pending motion by the defense to compel discovery and exclude the evidence that was derived from the use of Sentinel AI by both the Wexford Police Department and by the ADA prosecuting the case. So the prosecutor is going to oppose the defense motion, citing Rule 707, which is a proposed rule in Franklin that governs the use of AI-generated or AI-assisted evidence in criminal trials. And this proposed rule allows for the admissibility of AI-generated evidence if the proponent shows that the system was trained, tested, and used in a manner that is generally accepted in the field, and if its outputs are meaningfully verifiable or subject to adversarial challenge. So now we're in our trial court where Judge Grimm is holding a pretrial evidentiary hearing on the defense motion to compel discovery of all materials related to the use of the AI, including the logs, outputs, prompts, audit trails, and vendor documentation, and the defense motion to suppress the AI-derived evidence, arguing it's inadmissible under Rule 707, and ultimately that it violates due process and confrontation rights. So I'm going to turn to Judge Grimm for your thoughts on whether this proposed Rule 707 applies to the AI outputs used by both law enforcement and the prosecution, and whether the black box provision does raise sufficient due process issues for you to rule on the admissibility of the outputs. So, Judge Grimm, you've heard a lot of arguments and a lot of information from all sides, and I'm going to turn to you to lead the conversation from here.
Thanks, Liz. I want to start off by saying with absolute sincerity, I think that the thoughtfulness, professionalism, and the depth of prior consideration that we have seen from Christian, Andrew, and Jerome is phenomenal. I think this kind of discussion needs to be put on the road so that it can go elsewhere to policy folks in prosecution and policing at municipal, state, and federal level. It is one of the best discussions I've heard covering an entire waterfront, from why are we using this? What access do they have? What is the purpose for which it's doing? What are the legal standards that apply? And I think that in an area where, and I think it was Christian and Andrew pointed this out, these developments of this technology are going at a warp factor. And we're all trying to keep up with it. There's largely a regulatory vacuum, a lot of legislation. Christopher, I thought at some point last year that there were over 600 bills. Some of them may have been civil across the states that dealt with some aspect of algorithmic evidence. And I think that you pointed out quite correctly, as did Andrew, that these algorithms have been around forever. It's just that what changed the dynamic was generative AI, where this stuff seemed like you were consulting the Oracle of Delphi. It was all knowing. And as was said, this stuff is not trained to find the truth. It's just trained to predict what the next word will be like in response to a prompt based upon searching an entire large language model. And Jerome's questions and issues and analysis about how is it being used in the investigative phase? Does it affect the probable cause? Is it being admissible? These are all tough, challenging questions. A phenomenal discussion. I can't commend you enough. I hope somehow that this could be used as a catalyst for others to have the same kind of a conversation, because working together like this will get a better output than if we all just stay in our silos. Now, the judge has to deal with this. And so the very first issue that you have to take a look at is under the 707 issue, that this is a proposed rule. To take a step back, in October of 2023, my writing colleague, Professor Maura Grossman, and I were very fortunate to be invited by the Federal Evidence Rules Advisory Committee to talk about artificial intelligence evidence. I think the committee at that time was thinking, why isn't this stuff everything else? One of our major concerns was deep fake evidence of fabricated evidence coming in. And I think if you take a look at the president's policy that came out, pages 12 and 13 of that policy said we need to be careful about the impact of algorithmic evidence on the fairness of the judicial system. And one of the action points was actually for the Department of Justice to lead an effort to coordinate with federal regulatory policies to encourage evidence rules committees to adopt a rule, something like proposed Rule 901C that was being considered by the Evidence Rules Advisory Committee. Professor Grossman and I were the first ones to recommend a draft 901C, the version that was adopted by the Evidence Rules Committee to consider. And they had not yet decided to put it out for public comment, but I'm hoping after the president's White House AI policy that it will go out for public comment, because I think if people like Jerome, Andrew, and Christian had an opportunity, and you, Liz, to respond to this, it would turn out to if there is to be a rule, it would be a much better rule. And so I do hope that they put it out there for public comment. But the key in terms of 707, which is what they did put out for public comment, it's going out, I think, early this month, is a rule that says this algorithmic evidence, whether it's generative AI or anything else, is the result of machine-generated information, computer-generated information. And the questions about that deal much more closely with the kind of factors that we're used to in the Daubert or Frye hearing, which is it valid? Does it do what it's supposed to do? And is it reliable? Does it consistently produce reliable results when applied to similar data sets? And that gets us into the Daubert factors. Has it been tested? Is there an error rate? I think Christopher and Andrew made an enormously important point. There's no such thing as a single error rate. In admissibility issues, if you're looking at authentication, which is what this is, you only need a preponderance. That's 51%. That's just a teeny bit more than a coin toss. So that's not any great shakes. If you're looking at 70% accuracy, it may not be all right for brain surgery, but it's a lot better than oftentimes the human effort. So what is an acceptable error rate is not, it depends on the circumstances and the purpose for which the evidence is being used. And so one of the things that Rule 707 is saying is, look, if we were calling a witness, and this point I think was very well made by Jerome, a lot of times what you get, and I saw it many times in the court, is you get a very good law enforcement investigative officer. They've used a tool and they've used it over and over again. And to their knowledge, it's never been a wrong result. They don't know how it was designed. They don't know how it was tested. They don't know about any error rate. They don't know about what was done. They just know that if they use it and do it in this sequence, they get good information. They testify about that. They're sincere. They're honest. They're credible. But they have no idea how it was developed. That's not enough. We only have two flavors of witnesses in court. We have lay witnesses whose testimony must be based upon personal observation and cannot involve scientific, technical, or specialized information unless if it's within the scope of where we need experts. And we have experts. And lay witnesses have to base it on personal knowledge. And if I can testify as to how I use this device, but not how it was trained or its error rates, I don't have personal knowledge of that. I am not the proper witness to authenticate that. Now, as Jerome pointed out, that may be the defense counsel's best friend. on cross-examination where they say, yeah, I don't know, because he's going to take that right to the jury. He's going to get that cross-examination transcript. He's going to put it up on the screen. He's going to argue it to the jury. And Andrew's going to be concerned about where his case goes because his witness, who's a good guy, you're not saying he's a liar or she's a liar. You're saying he's telling the truth. He's being candid, but this stuff, you can't rely upon it. What 707 does is it says, wait a minute. You've got two rules of evidence under the federal rules. And I don't know about states, whether they have rules like this or not, but some states do, some states don't. There's a fairly new, came out in 2017, federal rule of evidence for self-authentication of electronic information. And if you look at Rule 90213, it's certified records generated by an electronic system or process shown to produce accurate results. And so how do you decide whether or not this Sentinel produces accurate results? The first thing I'm going to say is I think you're dead on arrival if you come in there saying, Judge, we're not going to give you the defense discovery to this. I think you've seen, while that happened in a concerning case involving the use of algorithmic analysis in a thing called Compass, which was predicting recidivism rates. And I think that the Supreme Court of Wisconsin in 2016, and I'm not critical of them because no one was thinking about this in 2016, but they said, yeah, it's proprietary information. You can't get access to it. The defense didn't have an ability to make a due process call. I think most of the thoughtful cases after that have said, there's no way. You've got two choices. Either don't use evidence produced by this device and go in there and do it, or if you're going to use this, you got to make a discovery. And judges, you're never going to convince a judge that a judge cannot fashion a sufficient protective order to protect it. And we saw that with some of the more sophisticated DNA analysis where they were coming out saying, oh, you can't do that. And all it takes is a judge saying, ain't coming in unless they have access to challenge it. So what 707 is basically designed to do is say, look, if you're offering evidence that was produced by computer-generated evidence, and that's broad enough to where it's going to be ordinary vanilla algorithms as opposed to generative AI or anything else, and if doing so with a live witness would implicate Rule 702, it involves scientific, technical, or specialized information that's beyond the understanding of the jury, then you cannot introduce it in the absence of a sponsoring witness who has the expertise to be able to testify. And on the key issues of all the things that we've been talking about, go into whether it does what it's supposed to do, unless you establish the elements under Rule 702 A, B, C, and D. Now, Rule 702 was modified, amended by the Evidence Rules Advisory Committee of the federal courts about a year or two ago to say that you got to have qualified expert who's involved, and the information has to be helpful too, that the sufficient facts and data have to be used in terms of getting the output that you're using. So that gets into your data set and how it's trained and how it's tested. And both Andrew and Christian were talking about this. That gets to whether in this particular case it was used for the right purpose, even if for another case it would be used for a proper purpose there. So whether or not the sufficient data has been used, whether or not the methods and principles that are involved in getting the result are, and if you look at 702, it now says reliable, and reliability gets into both validity, is it accurate, and reliability, is it consistently accurate? And then finally, that the result in this case is a reliable application of this reliable technology. So now you're going to have that. You can have a certificate, but the person who signs that certificate, and Jerome, I know this wouldn't happen with you, but I've seen defense counsel not saying this is not the right person to authenticate this stuff because they just use it. They know how to use it, but they don't know how it works. So you're going to have to go back to that person who knows how to do it. That admissibility rule right there, if it comes in, will kill the black box. I can tell you, but then I have to kill you, judge, and I can't disclose it. And what will happen is that the vendors who I have nothing but sympathy for prosecutors and defense counsel and police departments who are inundated with these people selling this stuff. It's almost like the old snake oil salespeople, right? I got this stuff. It's exactly what you need. And you can't have any way of comparing them or knowing it and all of that. I think those proprietary information things they're not going to survive at all. The judges are going to say you just don't get to use it. The notion of whether you can make a showing, that rule would go a long way. But it's only going to go a long way, Liz, if you're talking about admissibility, because these are admissibility issues. They're not issues. And as Jerome and Andrew and Christian have said, and they're spot on. There's a whole lot that happens before you get to admissibility, that entire investigative thing. And what we've seen is, you got to realize, it's only been since 2015 that the Supreme Court said that you had to treat cell phones differently than a steamer trunk in terms of Fourth Amendment law. We have a whole series of Fourth Amendment issues that come up all the time with a million different exceptions. So fruit of the poisonous tree, Jerome is going to analogize to fruit of the poisonous tree when he tries to say, you use this information from this investigation with this particular person, that would not have been admissible. That has tainted the officer's mind. He can't delete that portion of his brain that saw it and go and reconstruct it again. It's fruit of the poisonous tree. You have to realize that many of these legal standards deal with mere suspicion. They don't require probable cause. So what does it take? If you see a blurry picture in a surveillance video, in a break into a store in a robbery, and you look at it and you say, boy, this looks a lot like a person I had in another case, and I'm going to run the comparison and take that, make my photo array and go from there. Is that mere suspicion? It may well be. You have a lot of investigative activities that are justified by it. But we're going to have to explore all of these things in the context of some of this technology when it's actually being used. So what I think is, to answer your specific 707 question, is that we'll make it very clear very quickly that you can't hide behind the non-disclosure aspect of it. And the prosecutors, when they're looking at this, when they're negotiating, the economic consequences is, look, I'm not going to buy that, because why would I license that if I can't use it? It doesn't do me any good. And if I can't sell it, the licenses, because I can't use it, those licenses will change or they'll go out of business. So I think that part is going to be relatively easy. So now we know that you're going to have to produce the discovery. There will have to be some sort of protective order, and the judges will be pretty good at coming up with that. It'll be better if the parties agree to it and say, Judge, this we think is an acceptable protective order. The notion of black box and explainability is still going to be hugely important. Why? Because, to the point that all three of our distinguished panelists have said, one of the things is the strength of our system, but it's also a potential concern, is it's jury-centric, all right? So much of what we do in our system depends upon the jury deciding issues of fact. The judge can decide legal issues and preliminarily decide certain things, but there's a lot that we send to the jury asking them to understand. We know that when we look at scientific, technical, and specialized information for expert testimony in Rule 702, there's got to be helpful. But to be helpful, it has to be understandable. Because we all heard about the CSI effect where, I remember one time seeing one of the CSI things, and there was a person was stabbed to death, and they poured some kind of epoxy into the stab wound and came up with it. And they had this exact match of a knife they find when they had a search warrant underneath the bed of the defendant. You talk to pathologists about that, and they're like, they take them 10 minutes to stop laughing because it's absurd. But people see that. And part of the problem is, and I think all of our panelists would say this, is the public's they've already bought into this stuff. I don't know how this works, but if Waze tells me to take a left here, I'm going to take a left here and drive off that cliff. I go to Genesis. It's amazing, because we used to say that Wikipedia was 60% as accurate as an encyclopedia, but had 600% more information to it. So we started using it, and we never really relied upon it, but it was a first step to get us thinking. And a lot of these generative tools, even if you have to test the underlying information, as Jerome said, if you can say it was trained on this, and I can go back and look at this and verify what this is and how it fits, then the use that way is going to be okay, because you can check your work. It's when you can't check your work and you don't know where it came from or what it did or what the bias is or the error rate that it's going to be a problem. And so the challenge is that as these tools are being developed faster, because there's billions of dollars of investment going into here, they have enormous potential uses. But we have to remember that there's a concept in computer design that's called function creep. And you got to be very careful about it. It may be perfectly okay to use for this particular purpose, but not another, because it wasn't tested or trained for that. And you have a less tolerance error rate for the purpose for which it was used, as opposed to the purpose for which it was designed. So what I think is going to start to happen is that, number one, 707 is going to create a pretty consistent answer to the notion of, does the defense get to have access to challenge it? Yes, with a protective order. Number two is that we're going to have to get those questions before the court when it's an admissibility issue, which is all that 707 is. And if it's at a motion to suppress or at a constitutional issue, we're going to get into those issues that Jerome and Christian and Andrew were talking about. And then what we're going to end up doing is going back to the closest analog that we can find in old Fourth Amendment law. And there's all kinds of stuff. What we're not going to get here, because I jotted down the Leon case in terms of good faith. If there's a search warrant, all of the potential errors on that pretty much go down the drain after Leon if it was good faith by the prosecutor and you didn't have one of those four circumstances where the judge didn't do their job. Well, we're not going to have a search warrant in a lot of these things. Good faith alone in the abstract is not going to be important. It'll be important perhaps in terms of what consequences are there, whether it was a Brady violation or something like that you should have known and done. But one of the worries that I see is this, and buried within this little speech is, I hope, the answer to that specific question. I've gone way beyond that, and then I have launched on that. But oftentimes what happens is you've got to have really good prosecutors working with really good police to work together. Because what happens is the police investigation is before they indict. So they've done all this stuff, which may or may not be problematic. They go to the prosecutor. Prosecutor, you now have an indictment. Speedy trial clock is going. And you're throwing all this stuff out there. And the prosecutor doesn't necessarily know how any of these tools are being used unless there's someone like Andrew who has really focused on it. And they don't even know what questions to ask. So they don't even know how to prepare their law enforcement people or to say, hey, wait a minute, how is this stuff used? And now you got to get into this thing, and it's like a rugby scrub before the judge. And we're going to start to get a lot of these cases challenging it. I think a combination of dialogue among participants of the kind that we have here is essential. And I'm really greatly reassured and impressed that high-level police officials, prosecutors, defense attorneys, and computer scientists are talking about, let's work together to try and come up with it. You can do an awful lot if you have some kind of consensus as to how you can use this, and then disclosure so people can take their various positions depending upon what side of the V they're on to bring it to the attention of a judge to make a proper ruling. And I'll close with saying this. We've been here before to a lesser extent, not so much in the criminal case, but in civil discovery. When I was on the Civil Rules Advisory Committee of the U.S. courts from 2009 to 2015, we were all trying to figure out, what do we do with this explosion of digital information? This is subject to discovery. What do you do? Can you use computers to go through there and do your privilege review and all of that? And we were making it up as we were going along as judges. We were writing these opinions, and then when you got enough opinions, the Rules Committee came in and said we thought we had tidied it up. So we've been through this before. We can do it. Here's the challenge. This stuff is so much more sophisticated, so much harder to understand, because even the people who design this stuff sometimes can't tell you exactly how it works. And so we're just going to have to do it incrementally. And the key is getting the first decisions that come out from the judges, the appellate judges and the federal trial judges. Of course, they have the FSUP, so you can get a lot of case law. And certainly the Supreme Court, they get it right. If they get it wrong, then what happens is courts down the line, it's like a domino effect. They grab that opinion. Okay, this New Jersey court said this, I'm going to do the same thing. And if you're not careful, you can have 10 years go by and they've all been marching in the wrong direction. And to redirect that is going to be very challenging.
Thank you so much, Your Honor. And as I echo your sentiment at the outset about the richness of this conversation, and it just got 100 times richer. It's so rare that we get to hear the perspective of a federal judge with such expertise and depth as what you just offered to all of us. So on the rest of the panel's behalf, I thank you for that. I do want to take a moment. I've been reflecting on this discussion start to finish, and I'm going to offer my key bulleted takeaways as a senior law enforcement leader. And then I'm going to go around the virtual room and ask everyone to give the same 1 minute or less wrap on your key takeaways from today's conversation. So first, I think it's incumbent upon all of us in law enforcement to build organizational capacity, to think through these issues at the intersection of policy, technology, law, and of course, our paramount mission of public safety. very tactically that black box contracts today should be raising red flags immediately, that law enforcement should understand or at least have a dialogue with our prosecutorial partners about the impacts of evidence derived from certain technologies before executing contracts. If you have issues disclosing, you may have issues using, that we should think about secondary meaningful human review where that is necessary for purposes of admissibility. And a lot of people use the word analogs. There are analogs, and we have seen this before, as Judge Grimm just said, on the civil side. There are analogs that we can look to better understand how these issues might play out before we make decisions. That we should be thinking about identifying use cases and piloting in small and discrete manner so that we understand the collateral consequences of what we're using and really first identify if there's a problem that a technical system can and should be used to solve. That as leaders, we need to communicate at all levels of the organization, our posture around artificial intelligence, and build a strong policy at the organizational level. And as I mentioned in response to Christian's initial dialogue on this, like a lot of this is really a leadership challenge. And it's something that all leaders should be thinking about and talking about. And I commend all of you for your individual and organizational leadership on these challenging issues. Jerome, I'm going to go to you next.
So just to sum up for me, the potential for harm is too great in the criminal legal system to use outputs of proprietary black box systems as evidence or even as investigative leads without providing the defense with meaningful ways to challenge its accuracy, reliability, or its processes. And so I think that is what I'm hoping people can take away from what I said.
Andy.
Yeah, I think a lot of what I would have said, Elizabeth, you just went over, especially on organizational capacity. I think at a meta level, this starts with somebody who's in charge of it. I would say my second point would be you have to engage. This is not a technology about which you can now sit down and say, don't use it, we'll get back to you. Don't use it, we'll get back to you. The time is now. These products are going to solve cases for prosecutors. They're going to increase confidence in those prosecutions, and they're going to exonerate innocent people. But they're only going to do that if we use them right. That means engaging with them intentionally, begin with the end in mind. Is this trial evidence? Is this probable cause? Is this Brady? What is this? And work backwards from that. And I'd give the advice to start discreet. Pick jail calls, pick social media, pick a category, engage there, build the organizational skills and the expertise, and keep moving from there.
Christian.
I would say one other thing that I was probably remiss in mentioning is I spent a lot of time talking about internal and those stakeholders, and all of us that work for especially larger local municipal police departments, that community component up front is paramount. And I think you might do something small like a pilot or something like that to gather data and test the efficacy of a system. But before you do a wide implementation, we really do need to engage our community stakeholders. And having run working groups and town halls and things like that around body-worn cameras and drones, I saw firsthand the value of disclosing not only what we were going to do, but what we were not going to do. And also showing some of these tools up close. I think the challenge with AI, as we've kind of alluded to, it's certainly not condescending to say, hey, it's like really complicated to understand. It's complicated to understand for all of us. It's complicated to understand for some of the people that engineer and develop these systems. So that is going to be a continual challenge in terms of overcoming preconceived notions that folks have about systems, good or bad, and also keeping up with just the pace of change and the nature of the tools and being able to parse out like, hey, what is it exactly? Is it generative? Is it just an algorithm? Is it, to what extent do we use it? Is it used in investigations? Is it used for back office efficiencies? Is it used to just deliver communication? So I think that's going to continue to be a space that there's both opportunities and challenges as well, but not one that we can't afford to lean into. We've got to.
Thanks, Christian. I just jotted down humility and community. So I appreciate those additions to my list. Judge Grimm.
So let me just say this. Each of you, to one extent or the other, has made the notion of leadership on this. Well, let me jump in on that because the courts need to lead too. And I think it's wrong to wait just for when I get a case, I'll take a look at it and engage with it and I'll make my decision. That's just not the best way to deal with it because you have to look at resources. Now, I was enormously lucky for many reasons to be a federal judge, but I got a case from the moment there was an indictment, and I had that through the end of the case. A lot of our judges, colleagues in the state system do not have that luxury. You're sitting in criminal, And all of a sudden, you get notified on Friday that you've got this case on Monday. You didn't have 4 months to come up with a scheduling order and to sit down with the parties and say, let's talk about discovery. Let's talk about producing this information. Let's have deadlines for challenging admissibility. Let's talk about that. The two lessons I learned from my being a federal judge was the federal public defenders and the Criminal Justice Act lawyers that appeared in my court were phenomenal. The privately retained lawyers are superb, because you don't survive if you're not good in criminal defense. And that's why, Andrew, if you're doing that, you're going to be just fine. And what we did was, you have a couple of these hearings and you've got a person like Jerome coming in there and you've got a person like Andrew coming in there. And when they're explaining their positions, you're looking and saying, these are good positions. These people are smart. And what we ended up doing was, for certain types of things, like the kind of discovery challenges that came up all the time, when do we get our jinx, things like that, we would get together a group of them and we would come up with protocols. Protocols are great. So what judges need is, they need to have the discrete issues that need to be resolved for them to make the best decision that we can have them make. So that's early disclosure. The issue of, do I get it and when and how much and what protective order? That's number one. Number two, a time to have an opportunity to be able to look at it and decide, do I want to challenge it? Three, a deadline for filing that challenge to frame the issues, right? And part of that is whether you're going to seek discovery and have funding for an expert to be able to challenge it. And then four, the briefing of that so that the judges get the benefit in writing where they can. And then five, a hearing far enough in advance of the trial so it's not in the middle of a trial. If you can aspire to those steps and in the same time say, let's get good faith members of these different communities like we have in this discussion to talk about it in advance and see if we can have certain agreements that we reach that we can put into guidelines or protocols, we're going to get a much better output and the courts have to engage in leadership on that too, because it may be that the chief judge or the administrative judge is going to say, I'm appointing a judge in our court to work with the DA's office and to work with the public defender's office and to work with the police department to get together and come up with this thing and try and make proposals that all of our constituents can work with. That kind of leadership is going to be essential, because when we do this and we explore it and we understand the views of the other people, we're going to get a much better result. And we're going to get results, I think, that withstand scrutiny up the line, because the people looking up the line, they're going to be facing this for the first time as well. So leadership, I think, is going to be important from everybody involved in the process.
Thank you so much, Your Honor. And thank you again to all of our panelists. On behalf of the City Bar Presidential Task Force on Artificial Intelligence and Digital Technologies, we thank you for listening.
Thank you for listening to this episode of the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the City Bar. If you enjoy this podcast, please like and subscribe wherever you listen. Find more City Bar podcasts on Apple, Spotify, YouTube Music, iHeart, or at our website at www.nycbar.org/podcasts. Be sure to check out This Lawyer's Life, a professional development podcast where we talk with lawyers about seizing opportunities, learning lessons the hard way, and about what makes them tick. And don't miss Building Belonging, a podcast that embraces authentic conversations about DEIB solutions by amplifying the most marginalized voices in the legal industry and exploring spaces others dare not. This podcast was produced and edited by Jalen Martin.